Good morning and welcome to this Keating Chambers procurement webinar on hot topics relating to public works contracts in the aftermath of the Court of Appeal's judgment in Faraday. My name's Charlie Banner, QC, and I'm joined today by my fellow Keating Chambers procurement practitioners in order of appearance, Sarah Hannaford QC, Fionnuala McCredie QC, and James Frampton. Sarah's going to kick off today with where the dividing line now is between what is and is not a public works contract following Faraday. Fionnuala's then going to explore whether VEAT notices are, if they ever were, a reliable means of reducing risk following Faraday. And James then look at a range of other issues that certainly in my experience often get asked in the aftermath of Faraday. And I must say, having been in Faraday, when the judgment was delivered, we thought the answers were fairly unsurprising and provided some welcome clarity, but it seems from the range of questions and various range of sources as well that have come forward in the 18 months or so since the judgment, that there are an awful lot of perceived unresolved questions following the judgment. So hopefully today will provide you with some clarity. Please do ask as many questions as you'd like. We have a Q&A function, as is now hopefully familiar to everybody, at the bottom of your screens. We'll endeavour to work through as many of those as possible. How we propose to structure the seminar is we'll go through the three presentations with which all have slides, and then we'll have a Q&A discussion at the end, which I'll moderate. And so without further ado, I'm going to pass over to Sarah to start off on the subject of where the dividing line now is between what is and isn't a public works contract. So over to you, Sarah.
Thank you very much. I'm just going to try and share slides. Right, I'm hoping I'm now sharing slides. I'm sure someone will shout at me if I'm not. So, public works contracts, where is the line drawn now? What I'm going to do is start off with the basic starting point, which is what are public contracts under the regulations, and then obviously we can spring on from there. Unfortunately, public contract works legislation and case law is so complex that it's often a good idea to start back at the also, I'm afraid, rather complex definitions. So what is a public contract? A public contract is a contract for pecuniary interest concluded in writing between one or more economic operators and one or more contracting authorities, and having as its object the execution of works, the supply of products, or the provision of services. So that's a public contract. What is a public works contract? Well, that's a public contract which has as its object any of the following, and they are the execution, or both the design and execution of works, the execution or both the design and execution of a work, and the realisation by whatever means of a work corresponding to the requirements specified by the contracting authority exercising decisive influence on the type or design of the work. Now, that is a ridiculously complex way of saying this is all about works, but we've got the distinction between works and a work spelled out in these regulations. And a work has to correspond to specified requirements, and I'll come back on to specified requirements. And as of course I'm sure you all know, in the 2015 regulations this was all spelt out, whereas previously it just existed, this definition of specified requirements in Helmut Muller and the case law. So having started with the regulation 2, what are the elements of public works contracts? Well, there are 6. I put that in brackets because I kept writing them and deciding there were 5 or 7, but I've decided there are 6. In Faraday, you'll find the judge saying there are 4, but then the court goes on to say, oh, and some more in the case law. So my current tally is there are 6 elements of public works contracts. First of all, and obviously basic contract in writing, we don't ever really have a problem with that. For pecuniary interest, obviously Europe used pecuniary interest, we now put that in our regulations, not consideration. And then it's got to be between a contracting authority and an economic operator. So far so good, and apart from pecuniary interest you might think fairly obvious. What are the other requirements? The fourth one, the object of the contract is the execution of works or the realisation of a work corresponding to specified requirements. That comes from the definition I just looked at in Regulation 2. So the authority has to specify its requirements by taking measures to define the type of work or by having a decisive influence on its design. The question, of course, is what that means and where the dividing line is between having decisive influence and not. And then what Helmut Muller tells us is that the mere fact that an authority in the exercise of its urban planning powers examines building plans or takes a decision in the planning sphere does not amount to specifying in its requirements. So that's 4 of the elements. The 5th and 6th are on this slide, and one that gets an enormous amount of focus these days, I think, in discussions and in the case law, obviously notably Faraday, direct or indirect obligation to carry out the works which is legally enforceable. So not an obligation which is not legally enforceable, and I'll come back to that. And then the 6th, and arguably the most complex, certainly in its explanation in Helmut Muller and Rowan, is direct economic benefit. And sometimes this appears to overlap with pecuniary interest. So what is a direct economic benefit? Well, there are 3 possibilities. The third one has 3 subdivisions. That's what we're told in Helmut Muller and Rowan. So first of all, it's a direct economic benefit if the authority is to become the owner of the works. That's very often the case. But of course, if you're talking about a contract for sale, that's not necessarily the case, although obviously it might have a lease back. Secondly, the authority has to hold a legal right over the use of the works in order to be made available to the public. Thirdly, the authority either may derive economic advantages from the future use or transfer of the work, has contributed financially to the realisation of the works, or has assumed the risk of the work being an economic failure. So I think incredibly complex. I'll come back to it in a minute. But direct economic benefit, we're told in Helmut Muller, of course, is not the mere exercise of regulatory urban planning powers. So if you're a planning authority and you get benefit from approving a planning permission, that is not a direct economic benefit, obviously. So the million-dollar question, when is a contract not a public works contract? First answer, when it's a mere exercise of urban planning powers. Well, what does that mean? Because of course Europe don't have all of the member states don't have quite the same system as we do. We always look at this in this country as Section 106 agreements, and there's a very clear statement in Faraday on Section 106 agreements. This is the Court of Appeal commenting on a rationale, although I think arguably not the rationale, from the judgment in Midlands Cooperative. And what they said was a Section 106 agreement was not the kind of transaction that is governed by the public procurement regime. By its very nature, it wasn't a public works contract. Why was that? Well, the answer to that was because its essential object was to ensure that the community facilities, in that case, would be replaced if the planning permission were implemented. So the whole point of a Section 106 agreement, of course, is that the authority, gets some works in return for granting planning permission. So it's, according to the Court of Appeal in Faraday, really not the kind of transaction that's governed by the public procurement regime. Those are some very clear words. Do they apply in all cases? I think Charlie's going to deal with that in a bit more detail in a minute, but I just raised this question. Is it still fact dependent? I think the answer perhaps is yes. You may remember back in the day in 2010, when OGC was still a thing, they issued an annex to PPN 1210 dealing with Section 106 agreements, and if I may say so, possibly sitting on the fence. So the arrangements which may be entered into by local planning authorities can be complex, both in terms of the possibility of additional connected agreements to a Section 106 agreement and also the breadth of what can be provided for in one agreement. Therefore, it's important that in each case the intended arrangements are reviewed in the light of the public procurement rules to establish whether it's proper to conclude the rules do not apply because there's no pecuniary interest, no direct economic benefit, and no legally binding contractual obligation. Well, I think after Faraday, that is still the case, because is there a temptation now to load everything into a Section 106 agreement and say, by its very nature, that cannot possibly be a public works contract? Anyway, Charlie's going to look at that in a minute, and I will move swiftly on. Can you ever say there is no pecuniary interest? Quite difficult, I think, but it's worth looking at what Europe say pecuniary interest is. They don't say much about it, but Commission and Spain sets it out. For pecuniary, and this is the Advocate General, For pecuniary interest to exist, it's necessary the contracting authority bears the economic detriment, either positively in the form of a payment obligation or negatively as a loss of income or resources. Thus, the pecuniary interest requirement implies the contracting authority needs to use its own funds, either directly or indirectly. Direct financing will occur when the authority uses public funds to pay for the works or services. Indirect financing occurs when the contracting authority suffers economic detriment as a result of the method of financing the works or services. That actually sounds quite clear. When you put it into practice, not always necessarily so. What if you sell some land and maybe the value of the land took into account the scheme that someone was offering to build on it, obviously, of course, without any legal obligation to you to do so. I say obviously, but that's if you're arguing there are also no legal obligations. So that's no pecuniary interest where there may not be a public works contract. No specified requirements. Well, of course, you have to have specified requirements to fit within Regulation 2. But what does it mean? Because it's quite broadly defined. You've got to have a decisive influence. Do the cases help? Not that much. In Rowan, it was dealt with very briefly, but obviously there were specified requirements. The works were a leisure centre, including a cinema, a car park, possibly a hotel, and the court said Rowan was seeking to reposition and regenerate the area. What about some later cases? Well, in Impresa Pisarotti, there was a framework of requirements, and that framework specified the various technical and technological characteristics of the planned work, and the planned work was to do with construction of courts. So what the framework set out was specific requirements of each of the courts. So obviously that was enough for specified requirements. Commissioner Germany maybe does give us a bit of a clue, because what the court there does is distinguish between the detailed specifications which were imposed in the agreement there and what might not, although they don't actually say this, but what might not be sufficient to specify your requirements, which is merely a description of the fixtures and fittings. That case was about whether or not it was a lease, which I think is why they put it in that sort of language. But you'll see perhaps that from that not specifying your requirements really does mean not doing much more than in the case of a lease, just what you would do if you were taking a lease rather than if you were having the building constructed as well. Okay, the real knotty question, and I'm afraid I've been talking for too long already, no legally enforceable obligations. If you don't have any legally enforceable obligations, there's no public works contract. We all know that in Flensburg, although there was no decision, the Commission decided where there was a land sale, but the only sanction was to repurchase the land if they didn't build. That was not a public works contract because there wasn't a legally binding obligation to execute the works. Of course, an enormous amount of effort since then has been put into structuring an agreement that might fall within Flensburg. And that's, of course, when we get to Faraday, preceded by Midlands Co-op. Midlands Co-op being the longest and most difficult judgment one might ever want not to read. It's quite useful to have Faraday instead. So what was the position in Faraday? The obligation was contingent, and it was, but the contingency, which was to draw down land before the very detailed obligations clicked in, the contingency was in the hands of the developer. It was out of the hands of the authority. So once drawn down, there were, as night follows day, mutually binding obligations. And the court said it wasn't yet a public works contract because it was contingent and the obligations to develop were contingent, but it was unlawful to enter into the agreement because it would become a public works contract once the option was triggered. Now, looking at the judgment, that seems very obvious, and looking at the bits of the contract that's set out in an annex, it looks very obvious because it looks like a development agreement where there are obligations, but of course they were contingent. And as we all remember, in the heady days of Midland Cooperative, being the case that we all looked at, we thought that you could get out of, we might have thought you could get out of being a public works contract by having contingent obligations. Then, of course, you are not caught if you're a land transaction, and the cases on this are very fact dependent, obviously. In Quidnet, an agreement for a long lease, no express obligation to develop the site, no public works contract. In Midlands Cooperative, there was a sale of land, there was an overage agreement, there was a Section 106 agreement, and Midlands Cooperative, as reconstructed by the Court of Appeal in Faraday, said it was all about the Section 106 agreement, and the Section 106 agreement was, by its very nature, not a public works contract. Commission and Germany, a salutary tale, I think. It was described as a lease. Never rely on your label because it won't be enough. Although, of course, if you do label it development contract, you are starting with on the back foot. But anyway, this one was described as a lease. The building works, however, had not been started, and the lease followed on from the building works. And the court there decided that the main purpose could only logically be the construction of the buildings which were to be leased. It couldn't really be a lease when there were no buildings and there were detailed specified requirements in order to build them and then lease them. So are the specified requirements not all that straightforward? Let's nip quickly into no direct economic interest. I set out the three very complicated, well, the third one's very complicated, bases for saying there is economic interest. Some of them are obvious: owner of the works or legal right over the works. Then there is the question of deriving economic advantages from future use, contributing financially, and assuming the risk of the work being an economic failure. Most of those are straightforward, I think. They may not be what you would expect. The last one, I think, is more difficult. You assume the risk of becoming an economic failure. Does that include if you have a termination clause and you can claw back the land halfway through if the developer goes bust? Interesting question. Beware. Contracts which may be treated as a unity, we all know that the risk is there. The risk is often warned about, but courts don't very often decide to treat things as a unity so far. So we've got Helmut Muller, Remondis, and another warning more recently in Faraday. What else do we need to be aware of? The anti-avoidance risk, Regulation 18. I'm not talking about that. James, I think, is going to come on and talk about that in a bit. So I feel that I've probably got to the end of my time. This is where we get to, and I'm sorry that has been an enormous whirlwind tour of where we are on public works contracts. Where is the line drawn after Faraday? Well, what's on the right side of the line, according to Faraday, Section 106 contracts, but beware, I would say, of loading everything into a Section 106 contract to get round the rules. What is also on the right side of the line is no legal obligations to carry out the works. But beware, this talk seems to be full of beware. Beware that no legal obligations actually means no legal obligations. It doesn't mean contingent ones. There will be legal obligations in a minute, but aren't now. It actually means no legal obligations. Also beware of being too clever. Not that I'm suggesting anyone in this audience is being too clever, but if you set up something, as was done in Faraday, it may come falling down around your ears. And also beware, I would say, of spending too much time and money avoiding, I know none of us actually avoid the regulations, but in trying to justify a stance outside the regulations, because if you do spend a lot of time and money on that, you may nonetheless find yourself in legal proceedings. And slightly tongue-in-cheek, my last point about where is the line drawn, don't worry about a thing, because in the post-Brexit world, everything, no doubt, will be clear. Thanks very much. I'm sorry to speak so fast, but those are my views on the first question, where is the line drawn? I'm going to try and stop sharing now.
Thank you, Sarah. You have. Thank you very much indeed for that. Just to follow up very quickly on the Section 106 point, the rationale as I see it for the Court of Appeal appearing to say that Section 106s were outside procurement altogether was the comment in the Helmut Muller case that the mere exercise of planning powers wasn't enough to bring an agreement within the scope of the concept of public works contract. The nuance, I think, is that not all Section 106 agreements are confined to mere planning regulation. The SIL regulations for planning NERS, Community Infrastructure Levy Regulations 2010, Regulation 122 says planning obligations may only constitute a reason for granting planning permission, i.e. they can only be overtly taken into account by a planning authority if the obligation is necessary to make development acceptable in planning terms, directly related to development and fairly and reasonably related in scale and kind to the development. Though an obligation can only be taken into account if it satisfies those tests, it's still valid if it doesn't. And the practice of gold plating 106 obligations, and there's a sort of process often of nudge and wink with the local authority whereby they overtly don't have regard to the carrot, but everybody knows in reality it's persuasive. That practice does still go on from time to time. And obviously, if people were to bung in all sorts of things, as you described, Sarah, into a Section 106 post-Faraday, then that would be exacerbated. And those kinds of gold-plated obligations, to my mind, are not mere planning regulation. And if the point were tested, I don't think they would be exempted pursuant to that comment of the Court of Appeal. I should add, because noting that there are quite a few viewers from Northern Ireland, I think the position is the same under Section 76 of the Planning Act Northern Ireland, the Section 76 agreements being the equivalent of, in Northern Ireland, of Section 106 agreements here. There is, I don't think, any equivalent of the SIL regulations, but the SIL regulations reflect the position in common law, and so I think the analysis is the same. With that, I'll now hand over to Fionnuala, who's going to just talk about VEAT notices and tell us, well, whether they ever really were a panacea, and if they were, whether they remain so post-Faraday. So, Fionnuala, over to you.
Can I just check you could all see me?
Yes, absolutely, loud and clear.
Thank you very much. Right, after that gallop through what is and what is not a public works contract, I'm hoping VEAT notices will be something of a light relief. So my question is, are VEAT notices still a reliable means of reducing risk? And if so, in what circumstances? So just reminding us of the basics. Why do we want a VEAT notice? Because it's a protection against the first ground of ineffectiveness. As long as if you publish a competent VEAT notice and observe a 10-day standstill, and a competent VEAT notice, of course, has to be one published in circumstances where where award of a contract without prior publication was permitted by the regulations. So it must contain the following. I'm not wanting to teach you all to suck eggs, but you have there on the slide what it must contain. But I'm going to focus today on the object of the contract and the justification of the decision to award the contract without prior publication of a contract notice, mainly because that's what the Court of Appeal focused on in Faraday, and who am I to gainsay them? Although, of course, 5 might be important for you if, as a contracting authority, any other information which the contracting authority considers it useful to include. Useful is likely to mean that you need to do that in order to make your VEAT notice competent. We need to start, I think, before Faraday with the case Fastweb, that I'm sure you're all very familiar with, but it's, again, I think we should refresh our knowledge of it. So the position on VEAT notices was reviewed in Fastweb, and there the court held that the exception under the notice procedure must be interpreted strictly, i.e. if you're taking yourself outside the regulations, your VEAT notice and that your general conduct will be looked at strictly. And that the body responsible for the review procedure should, when verifying whether the conditions necessary to, in 99.4 of the regulations have been fulfilled, carry out an effective review. So again, I think look at it closely. And there we get the guidance that in Fastweb, useful guidance, which is that the justification by the contracting authority must disclose clearly and unequivocally the reasons that moved the contracting authority to consider it legitimate to award the contract without prior publication of a contract notice, so that interested persons are able to decide with full knowledge of the relevant facts whether they consider it appropriate to bring an action before the review body, and so that the review body is able to undertake an effective review. Of course, in Fastweb, the authority had cited technical reasons. It was a telecom system, but it turned out on closer analysis that it wasn't really technical reasons. It was just that it would have been a bit of a faff to have to go with a different provider. And so they fell down on that point. Now, Faraday. So echoing that, Faraday held that a VEAT notice must provide enough by way of relevant objective detail about the contract to enable the third party to decide in the short period allowed to him whether to launch proceedings. And then they said necessarily such a decision must always be a properly informed decision. So let's look at the facts of Faraday. it would be fair to say that the VEAT notice in Faraday did not fare well. The Court of Appeal didn't think very much of what was the information that was given to those who might be interested in viewing the VEAT notice. The description in the VEAT notice was that the main object of the agreement was an exempt land transaction. And the Court of Appeal held that that was incorrect, or at the best that was misleading. They said that the development agreement extended further than a transaction for the disposal or the transfer of land. It contained intricate provisions for the design and execution of a large development, which St Modwen, who was the successful bidder who obtained the contract, would carry out in accordance with arrangements provided in the agreement. So it stopped short of giving the full information in relation to that. And describing it in the VEAT notice as imposing no binding obligation on St Modwen left too much unclear. Nothing was said in the VEAT notice about the obligation borne by St Modwen, including to undertake works contingent only upon the drawdown of land. And the Court of Appeal said it would be easy to infer from the VEAT notice that no such obligations have been included. And they also criticised effectively the way that the VEAT notice was put together, because the description of the development as an exempt land agreement was presented not only as the object of the agreement, but also the justification. And given that it was a mistaken understanding of the object of the agreement, that therefore necessarily undermined the justification. But of course, describing it as an exempt land transaction was only the end, only the answer, and you needed to explain why it was an exempt land transaction in the VEAT notice, it seems to me. So the Court of Appeal again criticised that the statements that the council has not specified the requirements for any works and does not exercise a decisive influence on the type or design for any works, reinforce the implication that there was no obligation on St Modwen to carry out the works. And those statements did not alert a third party to the true nature of the transaction. The Court of Appeal went on to say that nothing was said about obligations for master planning, preparing project plans, applications for outline planning permission, subsequent preparation of development strategies, the obtaining of approval for details, etc. Seems like a whole host of obligations once the drawdown of the land had occurred. And then the Court of Appeal said the only part of the justification that purports to explain what the development actually was, rather than what it was not, was the statement that it was an exempt land transaction. The rest was all in negative terms and left no picture of the contract as it truly was. So where does that leave us? What must a notice do to be effective? Let's just recap on what we've seen from Fastweb and Faraday. You must assume that your VEAT notice, I've said likely here in the slide, it will be interpreted strictly by the court. It's got to provide clear and unequivocal disclosure of the objects of the contract and the justification for a lawful award without prior publication. Simply saying something is an exempt contract doesn't give you justification at all, and it doesn't really describe the objects of the contract. So one can see how the VEAT in Faraday became such a cropper. So when you're drafting, you need to say what the contract is, not what it's not, and you need to include the necessary relevant objective detail about the contract to allow a third party to make a properly informed decision about its rights. And you've got to include sufficient facts to alert a third party to the real nature of the transaction. So where does that leave you when actually drafting a notice? Obviously bear all of those facts in mind. And I, as always in these things, starting to try and draft the notice to make sure that it sets out all that you need to set out in order to meet the criteria set down in Fastweb and Faraday, gives you a good test of whether you're likely to be in trouble and whether you are likely to have a VEAT notice and a course of action that is likely to survive the strict review and interpretation by the court. And in my view, the harder that it is to write it, the more likely it is that it does not meet the requirements. And if you can't clearly explain what you're doing and why, it probably means that you've got bigger problems than just how you draft your VEAT notice. And particularly if the difficulties that it causes you is that it opens the contracting authority up to peril. So what's my guidance? My guidance is to be very careful, but it's a good checking process to draft your VEAT notice early on in the process when you're considering doing something which, having a direct award without prior publication, to see whether you think that this is something that you could stand up and defend in court, as you might very much be asked to do if somebody takes against what you've done. Thank you very much for listening.
Thank you, Fionnuala. So the headline is don't treat a VEAT notice as a panacea, but it can be a useful exercise as a sense check, at least. There's one point in the Court of Appeal's judgment which I'd just like to flag up for passing over to James, which is on the requirement for the diligence in producing a VEAT notice, which is one of the Fastweb criteria. The Court of Appeal said that they couldn't conclude that the council had not acted diligently without having seen the legal advice. And there's a slight perversity about that because the claimants had asked for the legal advice and the council had refused to disclose it on grounds of privilege. So there was a sort of element of circularity there, that the onus of proof, as the Court of Appeal saw it in relation to that limb, related to material which the claimant couldn't get. I'm not sure that aspect of the judgment would withstand stress testing in a case where it mattered. So anybody involved in preparing a VEAT notice, you need to be alive to the fact that material relating to that preparation may very well have to be disclosed, at least in redacted form, in the event that the matter became contentious. With that, and thank you, by the way, for the questions that people have submitted so far. Please do keep them coming. We've had questions on both subjects that have been talked about so far, which is really great. We'll come back to those later. In the meantime, we're going to hear from James on a sort of miscellany of points that have really come to the fore post-Faraday, recurring issues as people are trying to duck and dive their way around what is perceived to be the wider reach of the concept of public works contract since the Court of Appeal's judgment. So over to you, James.
Thank you, Charlie. So I have three topics which I'm going to be looking at, three kind of issues which do arise following Faraday. So first is going to be looking at Regulation 32. Second is Regulation 18, which Sarah touched on. And third, then considering practically how big is the risk. So to begin with, Regulation 32 sets out what's often called the sole supplier exemption. And the question really is, to what extent can an authority avoid having to run a procurement competition for a public works contract, which following Faraday it knows or suspects is caught by the regs, by relying on the exceptions in Regulation 32, which would allow it to kind of go to one supplier and negotiate directly. So I'll go through kind of each of those exceptions in turn. But before doing so, it's perhaps necessary to set out the general principles. So how is the court going to approach these regulations? Obviously, as we all know, the aim of procurement really is to promote fair competition. And that in this scenario leads to really kind of two principles. Firstly, the exceptions will be interpreted strictly or narrowly, similar to the VEAT notices as Fionnuala was discussing. And also that the burden is going to be on the authority to show that the exceptions made out. And specifically, they will need to show that they actively considered and got evidence which supported their view that the exception is made out. So the first exception, Reg 32.2a, and it's arguably not a true exception. In effect, it applies on attempt two. So if you've already tried to go through a procedure and you get no response, then you can go through exception A. The second exception is in effect works of art. So it's arguably obvious that if an authority wants a specific artist or sculptor in mind, then they should be able to go to them. For example, you may have a council now for some reason wanting to get Neil Buchanan to do its latest mural. But of course, it's unlikely to be of relevance to most public works contracts. So perhaps more significant exceptions then coming on to B2 and B3. And the first is competition is absent for technical reasons. And you really need to focus on two things. Firstly, it's the kind of the specifics of the words used. Firstly, competition is absent. And then secondly, technical reasons. And also need to note the express clarifications and limitations which do apply to exceptions 2 and 3. So if we go back, we can see below B, at the bottom of B, that 2 and 3 only apply where there's no reasonable alternative or substitute, and the absence of competition is not the result of an artificial narrowing down of the parameters of procurement. And in effect, and you can see some recent guidance, which has obviously come out in a very different context of COVID, but in effect, it's almost a scenario where there's only one supplier EU-wide who has the expertise or the technical ability to do the work. So some commentators have kind of taken this to an extreme and think, well, does this mean you in effect could never be sure without issuing a contract notice or a VEAT notice, which arguably may defeat the point. But a better view is probably that you need to, at least needs to be, you need to know there's no reasonably foreseeable alternative. But again, the authority needs to have carried out positive steps and evidence as to why it thinks that's the case. So exception 3, which may be the most likely for a public works contract, is the protection of exclusive rights. And obviously you can see the example given in the regs is IPRs. And for public works contracts, the argument normally arises as to whether, so is ownership of the land, if the developer owns the land, is that an exclusive right which needs protection by negotiating directly with that developer? And then really you need to distinguish in answering this question, which isn't straightforward, between different types of cases. So you may have a case where there's an authority who wants to build a new office block for its staff, and it doesn't really mind where, or it's not really material, which site is chosen. And in that situation, it's probably going to be very difficult to say, to rely on this exception, say, oh, well, look, but this developer owns that site, because by doing so, you're probably going to fall foul of the limitation that you can't artificially narrow the procurement. So really it's going to be, if you have a site owned by a developer and the authority is focused on that specific site for a good reason. So for example, if it's a site in the middle of a town where it needs refurbishment in order to regenerate and benefit the town as a whole. And in that scenario, there is an argument that the exclusive rights could apply, but it's obviously not straightforward. Not also because there's arguments as to whether moving down a step, although perhaps not on the wording of the PCR, whether the developer then needs to carry out a competition for its subcontractors. But perhaps another question which needs to be considered is whether, if this site is sufficiently important that it has to be that site, it could fall within the scope of the authority's compulsory purchase order powers. So then the question, does it need protection if the authority could CPO the site in any event? So in summary, while this is the most likely to be of relevance, again, it's not without risk, and obviously, as with all things, the facts of the specific case need to be considered. Final exception, I should note, is extreme emergency. And as touched on, there's likely to be a lot more guidance on this exclusion, I'd say, in the different context of COVID in the future. But it perhaps limited category of public works does need to be extreme emergency. In effect, there's no time to go through the normal procedure. And of course, it cannot be attributable to the contracting authority. So you can't be because the contracting authority's forgotten to plan properly and suddenly it says, oh, we need to carry out these works. So my second topic is Regulation 18, kind of the anti-avoidance rule, and particularly 18.2. You can't design the procurement with the intention of excluding it from the scope. And this was ground 3 of the appeal in Faraday. So if the development agreement wasn't caught by being a public works contract, the argument was, well, that's because they deliberately set it up that way, which fell foul of this limitation. This argument was dismissed by Lord Justice Lindblom, and you can note some of the language which he used, particularly towards the bottom half of the judgment, where he says it wasn't artificial, it wasn't an attempt to disguise, there was no bad faith, it wasn't a sham. And really his conclusion or his reasoning was that bad faith was required, and the optional nature of the development agreement here was a legitimate purpose, didn't include bad faith. But looking kind of for future cases, obviously you need to remember that the decision on this ground was obiter. Faraday succeeded on ground 2. And it's tempting to view that kind of the decision of the Court of Appeal was coloured because they'd already found the development agreement was a public works contract. And it's also open to doubt in the sense that the European authorities which they were looking at don't seem to include this similar language of bad faith. So you can see Helmut Müller, which is perhaps the key authority from the European Court they were looking at, just talking about clear evidence of intention to evade. And there's also, if you compare the wording of the judgment, so go back and see it in bold and underline, Lord Justice Lindblom said it wasn't unlawful for the council to seek to achieve a lawful contractual relationship outside the regime, but rather seems to be contrary to Regulation 18.2, which says you cannot design the procurement with the intention of excluding it from the scope of the regime. So it may be a question which, when it actually has to be resolved on the facts, there could be a different answer. And there's also importance for Faraday in the sense that now parties can see where the arguments lie on Faraday. If they try to take and obviously the development agreement in Faraday was a public works contract. If you now try and take it further, how can we change the development agreement from Faraday so it's not a public works contract? That could be considered deliberate and falling within Regulation 18.2. So my third topic is looking at, so obviously we've seen the risks which are now there for public authorities, but then how real is it? Obviously any challenge has to be by someone with standing. Two routes to challenge really is under the regs. You need to be an economic operator, so there's a requirement of form and substance, and a requirement of activity, and really you need to be a person, entity or group which was active in the market at the time. And there's a recent case of Community Article C, a case Sarah was in, where that's where the claimants who fell foul of. They weren't active in the market at the time or couldn't show they would have pre-qualified. In terms of judicial review, the statutory test under the Senior Courts Act is sufficient interest in the matter to which the application relates. And in the case of Wylde, Mr. Justice Dove looked at how this applied for procurement, and he did, in effect, found that in a procurement sense, is a more limited group of people who have standing than general judicial review. And in fact, you had to show that performance of the competitive tendering procedure might have led to a different outcome, which would have had a direct impact on him, i.e. the claimant. And then he looked at those before him who are largely council taxpayers in the area, local residents, and he said, obviously, while they had genuine concerns and objectives about the public interest, that was insufficient. He needed to be, in his words, remotely approximate to an economic operator. So where does that leave us? Well, in effect, there's a possible scenario where those with standing, i.e. economic operators, may not be interested in bringing a challenge on this ground. There's the lack of push factors. They haven't gone through a procurement where they've spent time and money and they're frustrated by the outcome. There's procedural obstacles. They don't have the documents. They don't have the knowledge of the project, possibly limitation issues. And there's also difficulties kind of succeeding. So, for example, the Nationwide Gritting Services is a Scottish case where there was no procurement carried out for salting contracts over 2 winters. But the claimant, after succeeding on limitation and other issues, couldn't actually show they would have made a tender and the amount of that tender. So they lost, not only on primary case, but even on a loss of chance, the court found, which would likely be your best case. They found they couldn't succeed. So economic operators may not want to challenge, and then following Wylde, NIMBYs, interest groups will often lack the standing. So really, it may be a situation where it's only kind of professional bodies, trade unions, who have the kind of unique mix of a desire and a standing with which to actually bring a claim where an authority has failed to comply with the regs in this way. Thank you very much.
Thanks very much indeed, James. And that last slide is a good place really to finish the presentations, because it does seem to me to be arguable that although Faraday has increased the risk profile of development agreements in one sense, in that things which were thought by some to be outside the scope of procurement legislation before is now within it. But what Wylde has done only a few months later has quite significantly narrowed the pool of likely challengers, because particularly in the case of planning-related development agreements, often the most likely challengers are those who are now outside the candidate pool following Wylde. So that's an interesting the courts are given with one hand and taken away with the other. We've got a few questions. We've got a little bit of time to go through them. I'll try and sort them in the order of the presentation. So firstly, dealing with Sarah's subject and what is and isn't within the concept of a public works contract. One question's been posed: what of a scenario where the economic operator, the developer, owes build obligations not to the contracting authority but to a third party, for example by a funding and development agreement to which the contracting authority isn't a party? Would or could that be caught either as a public works contract, or I suppose as by Regulation 18? I've got a few thoughts on that, but Sarah, what's your initial reaction to that question?
Okay, well, it's obviously going to be a bit fact dependent, but to start with, if there are two public authorities, so one is involved in a sale contract and the other is involved in a funding and development agreement, then there's a risk that the transaction needs to be viewed as a unity. On the other hand, if the third party in this scenario is not a public authority and the contract between the developer and the public authority contains no obligations, then I think there's a decent argument that there isn't a public works contract, because there's no public money being spent on development in that scenario. But Charlie, maybe you had some other thoughts.
Oh, I agree completely. I was just going to touch on the viewing the contract as a unity. I mean, it's quite clear both from the European case law, such as the unpronounceable Italian case about La Scala. No, I'm not even going to try. I'll mess it up. And Midlands Cooperative, because Midlands Cooperative, actually, the decision that was the subject of judicial review was a straightforward unconditional land sale. But the Court of Appeal, the High Court, was prepared to look at the overall nature of the transaction, which is why the Section 106 issues were central. But the Section 106 agreement wasn't the subject of the challenge, and nor was the Planning Commission to which it related. So it's quite a good illustration that in our domestic regime too, the courts are prepared to look at the totality of the transactions. And the question would then become, well, what, if any, contracts are there to which the contracting authority is party, and what do they contain? So that if you are to look at the whole, would there be the elements that Sarah referred to? One more question on the concept of a public works contract. Someone's asked, if there is what planners call a Grampian style obligation, worded along the lines, no development shall commence until, and then whatever the works are constructed, sufficient to mount an obligation of the nature that you described, Sarah, to engage in these. My inclination is no, it wouldn't, because the way I'd test that is, well, what would the authority's remedy be if there was a breach of that obligation? And as I see it, certainly if it was in a planning agreement, I think under a conventional contract too, the remedy would be to stop the development rather than to require the construction of the works, because of the negative nature. Therefore, the obligation wouldn't be an obligation to construct works. It would be an obligation not to do development, if you see what I mean. If it was too contrived, then it might be Article 18 in Regulation 18 that James talked about. Does anybody have any different views? Or?
Well, I was just going to say it rather depends on how contrived it is, I think.
Yeah.
And if you've got a negative obligation, well, it's not even an obligation really, is it? You've got something, X can't happen until Y has been done. Is that an obligation properly construed at all? So is it a contingent obligation a la Faraday, or is it no obligation at all? I mean, I think on one view and in English law, you might think it was no obligation at all.
Yeah.
Can't forget, of course, that Europe tries to construe things purposively. So it is possible that that is an obligation, but I think as construed and in a straightforward, as written there and in a straightforward case, it isn't an obligation. But isn't it a little bit like shoving everything into a Section 106 agreement? If you shove everything into one of these clauses, including a very detailed specification, don't you have to think, if it looks like a public works contract, maybe it is one?
Yeah, well, absolutely. Well, yes. The looks like a duck, walks like a duck, quacks like a duck. I think we've said at least twice in the Faraday case. Absolutely. I suppose, you know, if it was simple and not contrived, then it's not a million miles away from the Flensburg type example of step-in. The more, as you say, the more intricate it becomes, the more questionable. VEAT notices. Somebody has asked a question, I think it can be summarised as follows. Does a VEAT notice start time running for all purposes, including a damages claim, not just ineffectiveness, if it hasn't been seen by the aggrieved economic operator? Fionnuala, what do you think about that?
I should just say that that was a very short paraphrase of a long and scholarly question, for which thank you very much. But I think that this is the nub of it. So my answer is a qualified yes. I'm going to look at Fastweb, and then I'm going to hand back to Charlie because I don't want to steal his thunder. This was his glorious victory, not mine. But in Fastweb, the challenger there contended that the publication of the VEAT and a 10-day standstill didn't ensure consistency with effective judicial protection because it didn't guarantee that potential competitors are informed of an award of the contract, especially if it occurs during a period when activities are reduced or suspended. I suppose they might be suggesting, talking about traditional shutdown periods for industries. However, there's a pretty clear response to that in Fastweb. In paragraph 61, the court held that publication in the official journal guaranteed the transparency of the award. And one can see that because the official journal is used as the vehicle for transparency all over the union and for many different purposes, particularly availability of opportunities. And it's a fundamental part of the system, and all sorts of economic operators have access. Economic operators have access to the various tracking systems, which alert them to opportunities and which could alert them to VEAT notices as well. So it doesn't seem to me that that's particularly troublesome. And then in Fastweb, the court said, in addition, it should, even if the standstill period had lapsed, and there was still the right to bring an action for damages. And they made the obvious point in the following paragraph 63, which is that, of course, the legislature is seeking to accommodate divergent interests, namely those of the undertaking adversely affected by conferring upon it a right to bring proceedings and a short time scale in which to do so, and the interests of the contracting authority and the successful bidder or the successful the entity in a receipt of the contract, limiting legal uncertainty caused by ineffectiveness. So that's Fastweb. However, it can be the start of a train of inquiry, and it's that point that I hand over to Charlie to talk about his glorious victory in Faraday on that point.
Yes, no. In Faraday, they tried to take a sort of a timing point, which occupied the last bit of the judgment, the test is really whether there's actual constructive knowledge, whether my client knew or ought to have known of the grounds giving rise to the claim. The difficulty was the VEAT notice was deficient, and therefore the VEAT notice didn't give the information necessary to enable Faraday to understand whether the contract contained obligations, contingent or otherwise, of a nature that would make it a public works contract. And it was only, the Court of Appeal, so it was only after the development agreement was disclosed, which was actually after the claim was brought on a protective basis, only after the development agreement was disclosed, that time ought to have been considered starting to run. So, I mean, it seems to me partly, at least, the answer to that question, whether VEAT notices can start time, it depends on whether they're proper VEAT notices, and if they're deficient because they misdescribed or they're misleading, then they're not going to be a shield in terms of timing for any purpose. I think we've got one final time for one final question, James, for your area. It's a point you touched upon in your slides, and a point that people keep asking, perhaps for obvious reasons, in light of Faraday, about land ownership and whether a developer's land ownership would be a technical reason why competition is absent for the purposes of Regulation 32, which would provide an exemption. What's your headline response to that?
Sure. Well, obviously, I dealt with land ownership under the next exemption, exclusive rights. My instinctive view would be that whether ownership is a technical reason, and that's giving effect, I think, to the description technical, and also whether it means competition is absent. I think for both of those reasons, I would think it would face difficulties succeeding. And the ones which have been suggested could succeed in a DA context is more if a continuity of work. So authority wants a single point responsibility so that if something goes wrong, they only have to look at one contractor. That's where more the technical reason has been found it could exist, or failed on the facts. So I think land ownership is in my view, unlikely to be a technical reason.
You know, I'm inclined to agree. There's been an associated question about what about VEATs relying on developers' land rights justifying a direct award, presumably relying on Regulation 32. I think what I'd say there's, given the difficulties with to my mind, with squaring Regulation 32 as a way of getting around the reach of Faraday, I think what Fionnuala said in her final slide about, you know, if you're asking the question, if you're in doubt, then probably that's a fairly good indication that you shouldn't be relying upon a VEAT notice as a panacea. So I'd say again, all will turn in a particular case, but tread very carefully. It would be my response to that question. I think we've covered all the questions. It's cut 2 minutes to 11. So if anybody did have any further follow-up questions, please do feel free to follow up with our marketing team. I should add that some of you will have watched, hopefully, the procurement surgery that we held a few days ago. That is going to be a continuing thing where we'll happy to field any questions that people may have either in advance, communicated by email or on the day. So please do join us next one of those. If I presume everybody is on our mailing list, but if anybody isn't and got this from LinkedIn, then please do be in touch with Marie and Holly and our BD team. They can put you on a list and let you know about our next surgery and our next procurement webinars. But in the meantime, thank you very much for joining. Thank you to all the panelists for your excellent presentations, and we'll see you again soon. Thank you very much.
Thank you.
Thank you all.
Bye-bye.
Bye.